Good morning and welcome to the February edition of Bracewell's Environmental Essentials webinar series. I'm Whit Swift from the firm's Austin office, and I'm joined by Stephen Cook of our Houston office. Thank you for joining us. Our topic for today's Valentine's Day edition of the webinar series is environmental justice. My apologies for not coming up with a clever pun or play on words that tied our environmental justice topic into Valentine's Day. We have lots to cover in our half hour this morning, and we'll get right into it. First, as a way of setting the baseline, we'll quickly review a few key topics and definitions that kind of provide this baseline for this entire environmental justice field. We'll then talk about some key recent EPA actions in the environmental justice arena, and then we'll really transition into talking about how this might impact agency actions in permitting. And last, discuss, given what's happening in permitting and what we see happening in permitting, what to do as a permit holder, what steps a permit holder might take to prepare itself for what's coming. And with that, let's get right into it.
Thanks, Whit, for that introduction. A couple of key definitions that you want to pay attention to as you're thinking about environmental justice. And of course, that's the first term we need to define. As you look at the slide here, it's defined by one of the EPA legal terms as the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, and income, with respect to the development, implementation, and enforcement of environmental laws. The key part of this is to remember there's really two parts to this. There's the meaningful involvement, which gets into the depth and scope of the participation and the ability of the community to be involved in the permitting process. There's also the fair treatment, and this gets into the actual impacts in the community from the facility and neighboring facilities and such. And so as we go through today, you'll see that there's two parts to this, and you need to make sure that you're focused on both aspects of it. Second term we have here is disparate impact. And this comes from a civil rights aspect and affects more the permitting authority versus the permittee. But of course, if the state permitting authority adjusts their programs, it impacts how you go about getting your permits and what will be required of you. So the key question that gets asked here is, does the state permitting agency's criteria or method of administering its program or activities adversely and desperately affect members of a group identified by race, color, or national origin? So once again, it's the impact of the program. Doesn't necessarily have to be intentional, but they will objectively look at how the program's been administered, the impacts that are occurring on these groups, and is there a disparate impact? And so from a practical standpoint, you might think about if there's a community that has numerous facilities nearby, it's possible for EPA to reach a conclusion that there's been a disparate impact because there are other communities that don't have all those facilities right next door. And so those are the kind of questions and facts that will be coming forward as EPA goes through this analysis. And the remedy will be to take funding away from the state permitting authority. It's a fairly drastic remedy. We may talk a little bit more about that later. The next definition is cumulative impacts. And this refers to the total burden. And when you think about this, it isn't just from the emissions from the facility or the releases. It's including the chemical and non-chemical stressors and interactions that affect health, well-being, and quality of life of the individual of community. So you talk about both the emissions that are typically done and reviewed in permitting, but you also need to look at the state of the community itself, the total burden, the health and well-being of the community. And those will be non-traditional environmental impacts. You know, what's the health of that community? What's the risks that they have based upon their race and exposure to other things? The other aspect of this is that it's a broader time frame. It's not currently and going forward, but also looks back in time so that you get this entire parabola of time that you're dealing with and thinking about cumulative impact. So if you have a facility that is very well controlled now, but was near the community for 40, 50 years and wasn't so well controlled in those early years, those may come into how EPA thinks about cumulative impacts. And currently, this is a kind of working definition. We are expecting more from EPA on this. That'll be coming later this year, and we'll talk about that in a few minutes. So with that, turn it over back to you, Whit, about recent EPA actions.
All right. So first on this slide refers to some letters that EPA has sent to Louisiana and state of Texas regarding potential program deficiencies. These letters all relate to activity under Title VI of the Civil Rights Act, which Stephen mentioned earlier, at least in the discussion of disparate impact. And there, as a quick reminder, that Title VI of the Civil Rights Act prohibits a recipient of federal funding, such as a state permitting or environmental authority, from discriminating based on race, color, or national origin. And given the lack of a clear environmental justice hook in our foundational environmental laws, you've seen Title VI a lot in the EJ field in the last year or so, and non-governmental organizations have been, really successful in using Title VI of the Civil Rights Act as this hook to get EPA to investigate state activity, whether it's individual state actions on issuing a particular permit or looking overall sort of more broadly at a state permitting program. And here in Texas and in Louisiana, there's been a significant amount of activity in Texas. There are actually 3 open Title VI investigations where EPA has accepted a petition. One relates to a particular individual permit issuance for a site in the Port Arthur area. The second covers more broadly the concrete batch plant permitting program that the TCEQ administers. And the third responded to a complaint filed last summer that more broadly looks at the Texas air permit program and public participation in that program, and is seeking, seeking activity both under Title VI, and it's also calls itself a SIP call, basically asking EPA for these same reasons to call the SIP and take over the permitting process in Texas. So there's a lot going on. And in Louisiana, some of you may have seen it, but there was a letter that got a lot of attention that came out of Region 6, or came out of the Office of External Civil Rights from EPA, last year, associated with this investigation that they have of some particular industrial sites and geographic regions of Louisiana where there's a concern about air toxics impacts and increased cancer risk. And this Civil Rights Act Title VI process, there's an investigation, and it is in almost all cases there's an informal resolution of the complaint. The ultimate hammer on Title VI is to withdraw or withhold federal funding for the agency in question. But from what I've read and seen, that these Title VI complaints almost inevitably result in some sort of negotiated informal resolution where the recipient of the funding takes some action to basically settle it. And in October of last year, I believe it was, EPA sent LDEQ and also the State Department of Health what they called a letter of concern, raising or identifying steps that it thought LDEQ and the Department of Health should take in order to address the concerns that EPA had identified in its investigation of the Louisiana permitting program and air permits in particular issued to certain industrial sites. And there are a couple key things there that I wanted to note, that caught a lot of attention. Again, it was focused on air permits, air toxics, and cancer risk, but that letter included a recommendation that LDEQ with the Department of Health conduct a cumulative impacts analysis for pending permit actions and future permit actions affecting a particular geographic area, conduct additional ambient monitoring within the area, and then also develop a process to identify and address potential adverse impacts from things that actually aren't typically regulated by an air permit, such as traffic, odor, noise, things like that, and evaluate whether that, and how to alleviate what they believe were disparate impacts on particular communities. So again, these letters are signs of what EPA has been doing under Title VI and significant, and where EPA is concerned that there has been a disparate impact. You can see the type of actions that EPA was looking for to address those concerns. Next, this is a December 2022 document titled Principles for Addressing EJ and Air Permitting. And this is a document, I guess it's a memo that EPA issued late last year, and it aims to identify a sort of a framework for addressing EJ and air permitting. And a lot of it there, Stephen discussed the two pieces of environmental justice, sort of the public participation side, but then also the substantive impact side of the work. And those principles talk about both. Frankly, most of them are about that kind of public participation side, identifying the communities, engaging with those communities, enhanced public involvement. But it also does discuss this really hard part of this, which is the substantive EJ analysis and looking at impacts and disparate impacts and how to address them, and talk about, the conducting a fit for purpose EJ analysis as part of the air permitting process, and then taking steps to either minimize or mitigate disparate impacts that are found or that are associated with the permit action. Those are really hard things to do, and things that I think we all wonder how those types of analyses could be performed and what they would produce. But that's a document, again, it came out at the end of last year, focused specifically on air permitting, but it's something I'd recommend you check out if you want to see how EPA is directing its regions to, concepts it should consider in looking at permits and permit programs. The third document is the EPA's Legal Tools to Advance Environmental Justice, the Cumulative Impacts Addendum. This is an addendum to an EPA legal tools document that came out in May of 2022. And it's a fascinating document if you haven't looked at them yet. I was talking with Stephen about this. It reads, it's almost like it's the result of a brainstorming session that a lot of really smart people have worked on, where they sat down and they looked at, okay, well, what are our statutory and regulatory authorities under our foundational environmental laws, and how can we interpret or apply these to promote environmental justice concerns, to advance environmental justice? Even if we haven't used it that way in the past, this is how we can do it in the future. And so this is a document, both the main legal tools document and the cumulative impacts addendum they cover permitting for all media, they cover regulatory development for all media, and it's looking at, okay, well, here are the laws that we implement, and how could we look at this particular language? How might we be able to interpret this to advance environmental justice in either, promulgating rules, in reviewing standards when they come up for periodic review, or when issuing permits and looking at permit language and looking at, the monitoring requirements in permits and the like. And again, the most recent document, the one that just came out last month, is looking for those tools that specifically could address this idea of cumulative impacts, and how, in making those decisions and in implementing those statutes, EPA might be able to work toward addressing adverse impacts that are cumulative impacts.
For a community to effectively participate, they need resources. And EPA now is charged with funds given to them through the Bipartisan Infrastructure Act and the Inflation Reduction Act. They have many billions of dollars, in fact, several multiples larger than their typical annual budget of funds to go to communities on a whole array of different issues. And between the specifics of those bills and the administration's focus on Justice 40, where 40% of all grant programs and such are supposed to go to these environmental justice and similar type communities, you are going to see opportunities for these communities to get funding for technical resources, for being able to hire consultants, engineering, do actual monitoring, to truly be be able to effectively, on a technical basis, as well as the emotional basis that many of you are familiar with, be involved in the permitting process. So I think you need to be aware of those programs and recognize that money is now no longer really going to be an object that prevents a community from really getting involved in the permitting process. Second ongoing action right now at EPA is working on a response to an NGO petition they got regarding public participation. For those of you in Texas and familiar with air permitting and contested case hearings, yet again, that issue and that process is up for debate with EPA. In some ways, I feel like we have seen this movie before. This time, however, with the EJ focus and the funding available to the EPA as well in support that they've put into the civil rights and environmental justice focus, new office they've set up, I think you can see perhaps a more rigorous response and pushback from EPA on Texas and how they do contested case hearings and who's eligible for those and such. But there's going to be a lot of work on public participation, and it's going to be more than just holding meetings. It's going to involve some real substantive changes and things. So with that, I think we will go to the next slide and talk about some of the impacts you're going to see on your permits.
Sure. And so Stephen was mentioning that there's this more recent NGO petition on public participation, but this is really the second round of concern and EPA involvement in looking at public participation requirements in Texas. Those of you that work here in Texas and have gone through permitting over the last several months are likely aware that our permitting requirements, and specifically the public participation side of those permitting requirements, have changed and have been beefed up starting in, I think, November of last year. And interestingly, the change that was phased in late last year was not a result of recent 2019 or recent 2021, 2022 focus on environmental justice issues, but actually was the result of a Title VI petition that got resolved back in 2019. And it was interest in this issue and focus on public participation process in Texas that was several years old. And now the implementation has really finally kicked in. So I think that's one example of where you're going to see an impact on permitting is this change in the participation in the procedures. You know, in Texas now, there's this obligation. One, we've expanded our obligation as far as the translation of different documents during the public participation process and during the permitting process. But then also there's a new form that applicants are filling out that is called a public involvement form. And this is one where when you've got and there are a lot of questions that the regulated community has had about how to do this properly. But when you've got a project that's in certain areas of the state that's likely to have significant public interest, you've got this obligation to fill out a public involvement form and go through the screening process to evaluate what sort of outreach is necessary about the project. There's also this obligation for plain language summaries of what's happening in the application. So there are changes that have been made to the process that are designed to give more folks the information they need to participate if they want. And then I think, on top of those procedures to open the door, I think you can expect more meaningful participation with that additional information. And you certainly see sophisticated NGOs working with EJ communities on that participation and amplifying their impact in the permitting process. I think we've also seen, EPA involvement in its role as in Texas, they have approved these Texas programs that the TCEQ implements, but you can expect and look for additional EPA participation sort of driven by EJ concerns there. And that actually transitions to the second bullet on this, which is this point about EPA focus on permits impacting EJ communities. So again, another impact in getting back to this idea of that, our base environmental laws don't have a clear EJ hook in them. But one of the things that environmental justice, you've seen it do, and that I think it will continue to do, is at the very least, it will draw additional EPA attention or focus on permits that impact EJ communities. There was an example of this. EPA last year, there was in the Title V permitting process, a petition had been filed on a permit, and one of the big things it raised was environmental justice. And in responding to that petition in an EPA order signed by the administrator, they acknowledged that, in looking at a Title V permit, EPA's job is to see whether or not that permit meets the requirements of the Clean Air Act. And so there wasn't going to be an environmental justice chain to that permit, but they acknowledged that they were focusing particular attention on that permit using their existing tools because of its impact on EJ communities. And so the Title V permit review process in Texas is a good example of this. Is, their EPA Region 6 doesn't have the resources to look at all the Title V permit actions that flow through during their review period. But if they're focused on particular permits and they've got comments complaining, for example, about the level of monitoring or controls on particular units in that permit that impacted an EJ community, well, I think it will be more likely to expect EPA to comment and to seek changes or seek tightening up of, for example, the monitoring or compliance demonstration required for that permit. So again, I think that's another way that even, if you set aside sort of the Title VI, we're looking to we've got an environmental justice concern about the way this, environmental justice concern about the issuance of this permit or the way the permitting program is implemented. I think you can just see, more simply, if you've got a project that's going to impact an EJ community, well, it's more likely to get EPA scrutiny and have them looking at it really hard and finding things that they might want to change, improve, tighten up in that permit.
And as EPA is doing that review, they'll be looking for ways to reduce and equalize the burdens. And one of the first ways to do that is to have an accurate assessment of what that burden is. And so we anticipate seeing more recommendations from EPA for more monitoring. And that will include monitoring at the source itself, rather than a simple periodic stack test, to more continuous or more periodic testing and monitoring of the actual sources. You'll see more requests for fence line monitoring, and then requests for monitoring actually outside the fence line in the community itself. And with lots of that data being promptly made accessible on the web to the community for them to review. Some of the consequences will be that with that data, as it identifies exceedances of permit limits, the potential for citizen suits in federal court. Facility in Pennsylvania has just recently got a 60-day notice letter. I'm taking this type of publicly available data and turning it into a notice of enforcement for a citizen suit. So that's one aspect of their efforts to reduce and equalize burdens. Another, particularly for facilities that are located in high concentration areas like the Houston Ship Channel, Refinery Row, and Corpus along the Louisiana chemical corridor, you can expect to be asked to do more than just meet the requirements. The mere presence of all those facilities, some at EPA will take the position that there is already an undue burden in place. It's not an equal burden. Therefore, there should be no new facilities here, no expansions. Those should occur in other places where there are less burdens. I've heard some at EPA even talk about truly equalizing the burden, i.e. the levels of exposure to certain chemicals should be the same across all communities, whether they're EJ or not. That's not directly written in any document or such, but that is a logical conclusion one can draw that some in EPA have that perspective. And you need to think about that when you are planning for your expansions. In fact, in a recent enforcement action, one company was asked to consider hauling the waste away from the community rather than to the traditional disposal location to address this equalizing of burdens. So one of the aspects you have to do is be able to respond to that. So as you collect data, you do the monitoring, you need to be prepared to respond to the communities and explain what it is they're seeing in the data. On the cumulative impacts side, I think you'll see EPA push hard for looking, once again, for alternate sites for new plants or new construction and expansions. And it won't just be EPA. The Department of Energy likewise got billions upon billions of dollars for programs and will be investing in new technologies and new plants to support our transition to away from fossil fuels. And they've put in their documents, once again, the considerations of siting in non-EJ communities and such. So this principle of siting and avoiding EJ communities for new projects is across the federal government. It's not just an EPA phenomenon. Another way to also think about these cumulative impacts is, and this is a program in Texas, is we essentially could create what I would call toxic non-attainment areas, where a community monitor would measure a particular compound, say benzene, and if it gets above a certain level, then they consider no more benzene can be emitted in the area. We can't have any more impacts. In many ways, Texas has had this for many years. A number of communities, particularly in these concentrated areas, have had toxics monitoring, whether run by the industry or by the agency. And when levels get above, but typically they use the effect screening level that Texas has set, notifications go out to the facilities near the monitor that, hey, levels of this compound are too high, they need to come back down. And so far that program's worked very well, is that fairly soon something occurs at the industries and the monitors go back down. TCEQ has not taken enforcement action necessarily off of these numbers, but that's something you could see EPA look at doing. And I refer you back to the legal tools document to consider what tools they might use on that. Also, I think you'll see that some states will actually embrace this effort by EPA. And so they will create kind of an encouragement for other states to join them in adding these new requirements and making these additional considerations. So I think you may see, if you will, friendly settlements with states that are on board with everything EPA wants to do and kind of setting a bar, raising the bar on all sites. Similar how for those familiar with AIR program, best available control technology sometimes gets set. A company really needs their permit, so they'll agree to very stringent limitations, so it gets through faster, and thereby they have now raised the bar on those that follow them.
Kind of bridging between these two slides, I think that last point of yours is a real interesting one, which is so there are the states that are that would be inclined to work with hand in hand with EPA on pushing some of these issues, and in a way maybe you're changing, as you said, permit development, permits advance, become more stringent. I think the other real interesting side of this is what will happen in states where the state either questions its authority to do some of these steps, or where the state believes that it's addressing EJ concerns in a different way than how EPA envisions it. And what is EPA going to do there? Is it, are we going to see more and more of these Title VI type actions? Is that going to be the way they do it? Or are they going to use, for example, those tools that they talk about in those documents where, okay, here are creative ways to interpret this law, or different ways that we might interpret or apply this law that we haven't necessarily done in the past, but how could we use that in our permit oversight programs as a commenter or an objector or whatever, or through the enforcement side? How could they use those tools? It's going to be, a real interesting thing to see going forward. But what to do as a permit holder, the first one here is real simple. But it is just, if you're in a jurisdiction that has new public participation requirements, make sure you understand them and are aware of them and you do them properly. It seems like simple things, and it is in many ways simpler than some of the thorny issues about how you might actually change substantive permit requirements to address some of these concerns. But The fact is that if the slightest error in public participation, public notice, and the like can put a cloud over a permit action, require you to go back to square one and redo public notice, encourage more public participation, and the like. So that's a first and easy thing to do as a permit holder, but is just to make sure that you as an entity or the consultants that you're relying on to help you with your permitting stage know these new public participation requirements and will implement them correctly so that you don't have this cloud or uncertainty under your permit action that could cause everything to go back to square one because you missed one, you didn't dot one I or cross a T early on in the process. That's a simple and obvious one, but when you've got new requirements coming in, like we have here in Texas, and there's confusion about how to do them, that's an important first step that you need to do, kind of basic blocking and tackling to protect yourself in this new environment.
Then you really need to understand your neighbors. And it's not just be familiar with who they are, but how the agency is going to view them. You might consider running EJ Screen, the EPA's model. There's one out of the White House for Justice 40 that tells you more about the community. EPA looks at various census databases, public health databases, and such. So you might consider really going through all those different databases and see what they say about the census tract near your facilities or along your pipeline pathway or wherever your facilities are going to have an impact or pass through these neighborhoods, because that's what the agencies are going to be doing and that's what they're going to be looking at. And then you want to really build relationships with those neighbors and really understand what it is they're concerned about. What are their needs? And they will likely go beyond the traditional review of specific permit terms, but get into the traffic load, worrying about diesel emissions, noise, traffic patterns, other aspects as well. And keep in mind, because of the grant money and the reduction in cost for monitoring and the use of drones and those technologies, they're going to have more data to support their concerns or to raise questions about than they had before. So one of the things you may want to think about is, in the course of them building these grants, partnering with your neighbors and getting them a grant that helps them get those tools and create a monitoring network in the community that you're part of. And therefore, all of you have access to the data, and then you can understand what they're measuring, how they're measuring it, and help them understand what it means when they get the results. So you might think about that, and that's part of that self-assessment that you may want to do. Look at what data is already available about you and your site and your community, but also what else, where the holes are, and do you go about plugging those with additional monitoring and look. And then you need to pay attention to what's happening with other permits. As we said, the bar is going to continually be raised as other permits go through and other states do things. You need to be aware of what's happening in those permits, what are they being required to do, and be ready to adjust for your project so we can get through as well. And finally, always prepare company leadership. Let them know that the world is evolving and there may be new blips in the road that they're not familiar with because it may have been a while since they've gotten a permit or had a new project. So make sure they are aware of the potential traps you may fall in and give them ideas about what you could do proactively to avoid those if it's a time-critical project that has to meet a deadline. You've got to hit that time frame, then you may want to consider more proactive efforts to try to avoid any of those pitfalls. So with that, Whit, we'll turn it over to you to wrap up.
Sure. And last but not least on that, we didn't put a bullet on this, but track these developments. If you've been following this in the trade press, you know that EPA is working on a cumulative impacts assessment document that's supposed to come out later this year. That's going to be really important for how some of this is implemented. And to the extent it really defines a framework for doing these sort of site specific case by case impacts, let's, get that, understand it, and start to understand how it might impact your permitting. There will certainly be more developments on this, and there'll be a lot for folks to track, both what is being put out as far as guidance and policy documents and how that's being implemented and how it's impacting other permit holders. So there'll be a lot to track over the coming year. But with that, I think we're at or over our time, so I'll wrap it up. Thank you again for joining us this morning. We hope you found this interesting and even more helpful to your practice. If you have any questions about any of these topics or want to help tracking down any of the documents we've discussed, there's my contact information and Stephen's contact information on that last slide. Please feel free to reach out to either of us, and we'll be glad to help you find that information. And please join Bracewell again next month for next month's edition of the Environmental Essentials webinar series. And we hope to see you in Houston on May 9th. That's when we will be holding our next installment of our semi-annual environmental law seminar. That'll be May 9th in the Bracewell Houston office. Thanks again, and have a great day.